Moss Adams is pleased to present another in our ongoing series of continuing professional education webcasts. Our presentation will start in a few moments. Before we begin, here are a few things to keep in mind. You can customize both how you view our presentation and how you interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can also adjust window size and placement. At the bottom of your screen, you'll see a series of icons, each relating to a different aspect of our session. For example, you can click the file folder icon to download the group attendance sheet and a PDF copy of today's slides. You can ask our presenter questions during the webcast by clicking Q&A in the bottom left-hand portion of the icon bar and typing in your question. We'll do our best to answer all questions during the presentation or follow up via email. If you experience technical difficulty during today's presentation, refresh your browser by hitting the F5 key. We'll ask polling questions throughout today's presentation. Per the National Association of State Boards of Accountancy Webcast CPE standards, CPE credit will be awarded based on your participation in these polls. To respond to a poll, click the button next to your answer. If you're attending this webcast in a group, in order to receive CPE credit, you must complete our attendance sheet, available in the file folder icon at the bottom of your screen. Please have all group members sign the sheet, and please remit only one sheet per group. Also note, today's session will offer you one CPE credit. To receive credit, you must meet the requirements as specified by the National Association of State Boards of Accountancy. CPE credit can be awarded only to participants registered as themselves and is not available to participants who view the on-demand version. We'll track your progress and alert you when you've earned CPE credit. You can then click the certificate icon to open a PDF file you can save to your computer. We'll email a copy of your PDF certificate in 2 weeks if you can't download it today. As a reminder, the presentation you're about to see is not legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
Good morning and welcome to today's webcast. Are you complying with CMS's final 60-day rule for overpayments? I'm happy to introduce today's speakers from Moss Adams, Lori Laubach, Partner of Healthcare Consulting, and Sheri Hughes, Director of Healthcare Consulting. Lori, I will now turn the line over to you to get us started.
Well, thank you very much, Emily. I appreciate the opportunity to present on the 60-day rule. Today, Sheri and I will be discussing the 60-day rule. And we will not be spending a lot of time on background. We really want to make sure that we present why it's important to implement controls to mitigate, prevent, and correct. Federal and state regulatory agencies continue to emphasize that healthcare providers have the responsibility to disclose payments, and it's part of an overall compliance process and programs. But there's still a lot of uncertainty about how to comply and the related risk. The 60-day refund rule of the Patient Protection Affordable Care Act has gray areas and risks for organizations. So we want to talk about what those important areas are for your organization. And we're going to talk about when potentially the clock starts ticking and reporting should be considered. And after that background, we're going to talk about some cases, one case in particular, and kind of talk through that clock and how it ticks. And then at the end, we want to go through some areas of what organizations are doing for targeting best practice performance, and kind of talk about what we should be implementing for policy procedures, education, and monitoring. So Sheri, shall we start with a polling question?
That's great. Good morning, everybody. Our first polling question is really to define and target better our audience, know who's with us today. So if you could select the item that best describes you, a health plan, hospital, physician practice group, long-term care, home health, or hospice, supplier, or the ubiquitous other. If you could please complete that, we'll share with you the results. Well, it looks like we have about 42% are from hospitals. But we do have good physician representation, long-term care, and health plan. No others. We'll continue on with what's the latest of the 60-day rule. It affects all Medicare and Medicaid participating providers and suppliers. It requires the the reporting and refunding of known overpayments once they're identified. The rule's been in effect since March of 2010, but the final rule that applies to Medicare A and B was just finalized in February. The Medicaid rule has not yet been promulgated, so there's no final defining rule to Medicaid yet. Medicare Advantage, the Part C, and the Pharmacy Part D were finalized back in May 2014, and they're strikingly similar to the final rule that we just saw in 2016. The final rule defines the regulatory standards and for the reporting and returning of overpayments, and it applies broadly to all of those groups. But I'm going to go actually specifically and read some items in what the law does say. It requires that if a person has received an overpayment, they shall report and return to the Secretary of State or intermediary. They shall notify them the reason for overpayment, and there's a deadline for returning these overpayments, and the overpayment must be reported and returned at the later of 60 days after the date in which it's identified, and any corresponding cost report is due. At this point, the interpretation related to cost report appears to be for cost report specific items, but that is not fully clarified. Lori?
Sure. Thank you for the update. I know that there are people that may say, why should I care if the rule exists? There are several damages and penalties that can apply to an organization, starting with the False Claims Act. There could be damages and penalties underneath the False Claim Act. An organization could be liable for each overpayment, that's each overpayment, that was not paid timely, as there is an obligation to refund and report Medicare and Medicaid overpayments. The failure to report and return is an obligation for the purpose of the False Claim Act. In addition, the civil monetary penalty law also can be applicable if you have a known knowledgeable of overpayment that's not returned within 60 days or when the cost report is due. And there's also the risk of exclusion from federal health care programs for providing services to Medicare and Medicaid patients. In addition, the whistleblower activity has increased in this area. There allows a person to share in the recovery of those overpayments if they haven't been paid timely as a percentage of their recovery. And then finally, one thing that we didn't note on this slide that I think is important for everybody to think about is the Department of Justice Yates memo that came out in 2015. There's a risk for management and board if we're not compliant. And we've seen a few cases recently where the CEOs have been sentenced to some jail time for some stark obligations and things like that. So now that we've scared everyone, let's start talking about a recent case that I think is important for us to all pay attention to. Sheri, can you give us some background?
Thanks, Lori. Here's an example that personally I find pretty frightening. It's a case with the New York health system. The complaint alleged that the Continuum submitted hundreds of improper claims to Medicaid in 2009 and 10 on behalf of hospitals due to a software problem that was from their Medicaid managed care plan, wasn't the hospital's error. The government, though, alleged that despite becoming aware of the software issue in 2010 and being provided additional information in 2011 by one of their own hospital revenue cycle employees who virtually identified all claims in the issue, the hospitals failed to take appropriate steps to repay the claims until March of 2013. So they essentially held on to that for 2 years. They did nothing further with the employee KANE. It's the KANE case. His analysis. He was actually terminated shortly after completing the analysis, and he became a whistleblower. In February of 2011, the hospitals repaid 5 claims. New York identified additional amounts of wrongful claims and brought those to the hospital's attention. The hospitals began returning their overpayments in April, but did not conclude until March 2013. Not until the Department of Justice issued a civil investigative demand in June of 2012 had the hospital repaid more than 300 of the affected claims. The hospitals never brought KANE's analysis to the state's attention, and the Department of Justice goes forward and seeks treble damages plus an $11,000 penalty for each improperly retained overpayment. New York State seeks treble damages plus a $12,000 penalty for each overpayment. The complaint alleged that defendants delayed fully repaying the Medicaid overpayments for 2 years after the overpayments were discovered in violation of the False Claims Act, reverse false claim provision. Pretty frightening process. Lori, can you tell us more about the ruling?
Sure, Sheri. The KANE ruling actually is kind of interesting. It appears that the hospital was delinquent in many ways. We wish we could say that we don't see this out there in the marketplace, but we do see where overpayments and refunds take a bit to get done, let alone validation of timeliness by management or compliance. But it doesn't mean that they should, that the case is a good example, other than there's a good example of being not careful about following up on what is an identified issue. As it relates to the case, the court argued the overpayments were identified when KANE sent the email and the spreadsheet was received and triggered the 60-day clock. But the hospitals argued KANE's email provided only notes and did not start the clock. But as we can see from this KANE ruling on the slide, the court sided with the government. As it said in the slide here, it says 60-day clock begins ticking when the provider is put on notice of the potential overpayment. This is much more stringent than what CMS standard is in the 60-day rule, which is when an entity has identified the overpayment. So this leaves it open. This type of case leaves open to trial whether there's going to be an obligation to refund and could give rise to a false claim liability. The court recognizes that providers may not realistically be able to determine and identify payments within 60 days, but as there is a complex issue that may take time to quantify. But there are, from this particular case, they said you had the information, you were put on notice. But there's still differences from state to state on what are the requirements for returning overpayments. So one of the things we'll be interested to see is what happens and plays out related to this KANE ruling and how other hospitals that or providers that take time to refund something. In the final rule in February this year, there was some definitions that were put into place in the ruling that the regulations that are really important for us to talk about. We're not going to talk about every one on here, but we are going to kind of give you examples related to some of them. So let's start with what is an overpayment. So Sheri, do you want to talk about what is an overpayment?
Certainly. Well, we'll talk about overpayments as they apply to the rule. The key condition of payment not met, that's been a long-standing definition under CMS. But the key element is whoever receives an overpayment, money under Medicare Medicaid. What is not defined is the applicable reconciliation. It probably refers to items typically reconciled through the cost report that we mentioned before. It does include overpayments not caused by the provider, as we saw in the example of the KANE case, such as a MAC edit problem for paying for non-covered service. We've all seen those examples. And then there's no offset for underpayments. But an overpayment is defined as any fund that a person receives which the person, after applicable reconciliation, is not entitled to. The Medicare overpayment is a payment that a physician or supplier has received in excess of amounts due and payable under the Medicare statute and regulations. We give these particular definitions because when you go through and are working a court case or a legal case, these kinds of terms are going to be critical for your investigation process. The overpayments are included but not limited to findings of upcoding, incorrect codes, high modifiers resulting in a higher level of reimbursement, insufficient or lack of documentation to support billed services, services billed under the wrong provider, a lack of medical necessity, duplicate payment, payment to the incorrect payee, or any other finding that reflects an overpayment that was received as a result of an inaccurate or improper coding or reporting of a health care claim. Identified overpayments are overpayments that have been reconciled and must be reported and returned. As you can see, more types of overpayments are included now in the rule. Now, Lori, let's move on to identification.
Yeah, sure. Let's talk a little bit about an overpayment as it's defined. Now that we've defined an overpayment, let's talk about the definition of when it actually is quote unquote identified. The regulations discusses the exercise of reasonable diligence. A simple overpayment identified during the normal course of transactions would be reasonable diligence as the funds create an overpayment. Reasonable diligence is defined as including proactive compliance activities conducted in good faith. If an organization does not have a compliance program in place or have compliance activities or have undertaken only minimal compliance activities to monitor the accuracy of claims, this could create exposure. There are caveats for more complex situations, and that would be if CMS recognize that there's a sophisticated reimbursement questions require significant use of internal and external resources, due diligence, document review, and occasionally financial and statistical analysis. They recognize that, which is important for us because there are some situations where we cannot easily identify what is the true quantification of the overpayment. One of the key things about this regulation is that if the person fails to exercise reasonable diligence and the person in fact received an overpayment, they are leaning toward that proactive compliance element and saying that as you work through your regular processes of compliance, you are looking to make sure claims have been filed accurately. So we go back to, is your claims filed accurately, completely, and match what the service was provided. They also provide guidance on the receipt of credible information. Credible information that could give rise to a responsibility to conduct an investigation with reasonable diligence. That's information that supports a reasonable belief that an overpayment may have been received, and determining whether that information is sufficiently credible to merit an investigation is fact-specific determination. So we, as organizations, will get some type of complaint or incident that's been reported to us, and then we must go through the process of determining if it's credible information. And then that is the question of, that is when we have identified that we do have a potential overpayment. But we haven't actually gotten to the point where we quantify that. So some areas we want to talk about is really how do you identify an overpayment, and then we're going to talk about the next step of reasonable diligence. So Sheri, you want to talk about what is an area where you might see an overpayment?
Certainly. Often a charge is placed incorrectly on an account and it's credited soon after the services are billed and or paid, and now you have a credit on an account that resulted with an overpayment. So that's one of the simple items that you can identify as your normal day-to-day. You'd correct your claim, you would resubmit it, and that would be correcting the process. So the normal day-to-day, when you're looking and you see that your payment is in excess of your charges or services, then you know that you've identified a problem with your credit. For projects with Part A entitlement, the quarterly credit balance is one of the ways that people look at reviewing their analysis of their Medicare. If you're doing this only quarterly, however, you're going to be outside of your 60-day follow-up. Some challenges with the normal day-to-day process is knowing when the overpayment was created. In some systems, people have a hard time identifying the receipt, and that it now becomes a government or Medicare overpayment. Identifying the proper payer in the credit process, is the receivable assigned to the proper plan? And it's important to continue to be reviewing those items as you go forward. Additional items or recoupments are considered overpayments. Routine monitoring, overpayments are often found during the routine monitoring of charging practice to see that something was charged in error. Also, we see internal audits and investigation. These are where the much more complex process where a lot of work goes into looking at all of the data, finding out where all of the features of those live, and then how you track what it means and what the quantification is. There are also payer-identified overpayments, and payers are getting very much more involved in the overpayment process as time goes on. Once they identified that overpayment, unless you disagree with it and file an appeal, those amounts should be refunded within the 60 days. So, Lori, are you seeing increased collaboration between the revenue cycle, finance, and compliance teams as it relates to credit balances now?
Actually, I have been seeing this. This has been great to see the team effort to make sure that we recognize when a overpayment exists, to the point of finance either cutting the check or actually recoupment being processed by the revenue cycle team. And then compliance monitoring and looking at lags, timing, and saying, are we meeting that 60-day rule? And actually prompting reports to management to say we are or we aren't meeting those 60-day timeframes. Some of the tricky part about this metric is identifying when a refund is actually supposed to be occurring or when the recoupment is supposed to be occurring. So it's important to define that within your billing system or your system to say, when did the refund actually get triggered? Is it the point that you said time to cut the check, or is it the time that you actually started the investigation? So there's some timing differences that we'll talk through as well. But yes, it's been great to see some of those changes are going on where there's metrics, reporting, conversations going on, definitions going on. So it's not just driven by compliance or driven by revenue cycle, but the team is looking at it together. So what is reasonable diligence? I know when an organization completes regular monitoring, they may find a situation that creates an overpayment. But at that point, we may not know that the overpayment occurred and what the impact is. As we talked about reasonable diligence on the previous slide, this includes both proactive compliance activities conducted in a good faith by qualified individuals to monitor for the receipt of overpayment and investigation, conducted in good faith in a timely manner by qualified individuals in response to obtaining credible information of the potential overpayment. Well, that's a mouthful. That's how CMS is defining what they expect organizations to do to support reasonable diligence. So this is a requirement of a proactive compliance activities and approach to actively investigating whether overpayments exist. And this also, CMS goes on to say that we believe that compliance with statutory obligation to report and return received overpayments requires both proactive and reactive compliance. So sometimes we may be going along and doing proactive compliance, but we may not find something during our regular proactive monitoring, but we do find something through an incident or reported complaint or concern, or there was one thing that seemed odd, so we follow up on that. But they do say we advise providers and suppliers to undertake such efforts to ensure they fulfill their obligations underneath this act, which is making sure that we return our overpayments within 60 days. We believe that undertaking no minimal compliance activities to monitor the accuracy and appropriateness of providers or supplier claims would expose a provider to liability. So not taking the monitoring that you're doing and considering whether there's an overpayment or repayment due it would be considered to be reckless disregard. So this does document a need for a compliance program that's proactive and reactive. And that means being able to keep up with our proactive approach, and as well as being reactive to those incidents. But, sometimes we may not find that overpayment, and that may be because our program is looking at certain areas, but that overpayment came up in an area that something that we didn't look at. So we need to think about, what we're looking at from our work plan perspective is really hitting those high-risk areas, and do we have controls around certain points. So when we do encounter that one situation which isn't part of our regular monitoring, then we need to make sure that we have some type of corrective action plan to say how do we put a control to prevent that in that area. And then also making sure that we include in our monitoring and our proactive compliance is our hospital quarterly credit balance reporting process included in that compliance program review. Does somebody look at that and make sure that the information that's being reported in that matches what we're actually experiencing in the hospital? So let's talk a little bit about when the 60-day clock starts. So we kind of created these buckets, and hopefully this answers some of the questions we have, some of the questions that we have related that are being posted onto our question and answer area. So when does the 60 clock start? Well, we have a whiff. So what we've had is we have a situation where somebody has reported an incident or an allegation of an overpayment via hotline complaint. But we do not have a clue at this point of whether or not it's accurate. So at this point, we haven't started the clock because we haven't really determined if there's a credible allegation. Our next step is to investigate and determine if the allegation is viable or now move to a credible allegation that the overpayment may have been reviewed. Again, at this point, we have a credible allegation, but we actually haven't quantified or even know how much was overpaid. We have reached what CMS calls info that supports reasonable belief that an overpayment may have been received. Examples would be where we've done a review of records, we learned that there's a incorrect coding going on, or there is a hotline complaint that indicates that there's certain type of accounting processes not in place for cost reporting, to even Stark issues. This is where, we say at this point we don't know how much is overpaid, but we now need to start talking about, we have a credible allegation, and this is where the clock would potentially start ticking. So we have moved to this not quantified stage, and this not quantified stage is where we need to develop our overpayment process to go back and determine what is the overpayment that is going to be quantified and submitted back to the government agencies. We must use a diligent process, though. We can't drag our feet. This needs to be something where we show due process of making sure that there is an assessment of the issue. What does the assessment relate to? Can we plan and determine the amounts from what we have so far? This may be a process step where we actually have to obtain an outside opinion related to the exposure of, let's say it's a Stark issue, or we're using commercial reasonable methods, so we have to make sure we have the right data to analyze it. Or in a case where we may need to extrapolate or use a statistically valid sample, we may need to sit down and look at it to say how many more items are we going to have to select in order to get a statistically valid sample. Per CMS, you may take it, and this is part of 81 Federal Register 7662, you may take at most 6 months from receipt of credible information absent extraordinary circumstances. So remember that CMS does recognize complex investigations, such as items to be reported under the self-referral disclosure protocol, but it is very fact-specific. So they do have this 6 month from that point where you have a credible allegation. Now, the quantify stage is where we have determined where the overpayment has been quantified, and we've determined that we have no counter arguments. We're certain of the amount of the overpayment, and that overpayment may have been extrapolated from some probe samples, it may be extrapolated from a statistically valid sample, or it may be 100% of the items that need to be refunded. But this is the point where we really want to make sure we have the right universe. We have tied it out to the areas that that we're pulling the data from, and that we are giving back the right information. But the key to this clock here, from whiff to quantify, is that we're not dragging our feet. If we are intentional, not moving at a certain pace, or not diligent, this could be considered reckless disregard. So think about when you get that incident, moving to the credible allegation, doing your investigation, determining what that is, then the clock starts ticking for that 60-day, if not 6 months, if you have a complex situation. So this is the 60-day clock, and so we're going to move on to how far back do we actually have to go? Sheri?
Well, we'll go over the look-back period here. For Medicare, it's a 6-year look-back. For the self-referral disclosure protocol, after the March 14th, it's a 6-year look-back. And the False Claims Act is a 10-year look-back. The good news was in the proposed regs that Medicare was going for a 10-year look back, so that's a positive. We have questions still. If the overpayment was discovered through an OIG or RAC audit, what's the responsibility to look back and how far? With Medicare for simple overpayments, it's a 6-year look back. For the False Claims Act, there's existing statutory duty to report and refund within 60 days, and they're looking at a 10-year. With the self-reporting disclosure protocol, currently CMS can only collect financial information for 4 years, but they are seeking OMB approval to go back to 6. And the providers may voluntarily provide information for years 5 and 6 and report and return for 5 and 6 through other means. These look-back periods require providers to report and refund received during the prior 6 years. It's a significant change to the current overpayment and refund practices. So let's move on to a hypothetical case to try to put these directions into quasi-reality. Lori?
Sure. So we have a case where it's all hypothetical and nobody that we know has had this done, but we want to talk through some different steps within the 60-day rule. And we know that there are other elements that can affect how an organization investigates and handles an overpayment, but let's just talk about when should this clock start ticking. So here we have a compliance officer who received a report from the hotline, and there's an anonymous caller that has alleged that Dr. Busy, a productive and highly regarded orthopedist who joined the medical group 4 years ago, employs an NP and a PA where the billing office has been improperly billing as incident 2 while he's on the golf course or doing other things. So where did the 60-day clock start ticking? So the questions we have is it yes, report and refund. No, no evidence was provided. Close the report. No, but open an investigation. Please answer one of those questions. I think it's interesting as we talk, as everybody's answering this about situations like this. I think all of us may have encountered this type of situation over the years, and we still encounter these type of situations. So it looks like our responses is that we have yes, report and refund at 35%, no, but open an investigation at 64%. Sheri, you want to go over the results and the correct answer?
Well, the correct answer is really number 3. The provider can't ignore the allegation, but they must immediately conduct that reasonable inquiry that Lori spoke of or risk that reckless disregard and initiate an investigation immediately. While there really are no right answers, at each of these points you're getting more and more information, and it allows you to really put a full investigation together. The billing could be perfectly appropriate. Dr. Busy could be at the practice, or another partner could be supervising, and they could be billing at the 85%. But the provider cannot ignore the allegation. They must conduct a reasonable inquiry or risk that reckless disregard. In part 2 of our hypothetical case, we continue on. Under the attorney-client privilege, the compliance team does a review of charts where the PA services were billed incident 2. Some charts show 0 evidence of direct physician supervision. Some indicate there was physician supervision. So the compliance department then checks on the policy on overpayments, which in part states that the hospital identifies that overpayment with the first credible allegation. The compliance officer contacts their in-house legal department. So Lori, now has the 60-day clock started?
Well, arguably no, because no documentation doesn't necessarily mean it didn't happen. CMS might disagree on that. This would be something we would have to sit over a table and actually discuss about it and look at the documentation related to that. But again, the inquiry is not over until the groups, under the policy, the combination of facts might constitute a credible allegation. but have we actually looked at all the facts related to that particular issue? So for those charts where it shows zero evidence of direct physician supervision and they were billed incident 2, is there examples we can find within the physician schedule to see if they were in the building, or charts for that day that show they were in the building? But there might be some weaknesses related to the documentation, which is an issue, but it's also something we need to consider. So we now do an interview of the PA, Paul, and present him with the results of the chart review. And the PA confesses that the physician is not always present and that sometimes claims go out as incident 2 when the physician is not present. So now that we find out more this additional information, let's ask another polling question. So if you can look at this question, it has on here, is a 60-day clock ticking? Sheri, you want to take this?
Certainly. So we can say no, the overpayment is not yet quantified or quantifiable. No, we're still in process of quantifying the overpayment. Yes, there is actual knowledge of an overpayment, or yes, the overpayment applies to claims on the chart review. So if you could pick your answer. Give a second. So the correct answer is the yes and yes, but we look like we're 58%. We're seeing that there is an actual overpayment. So as we walk through that, the issue remains whether the overpayment is quantified or quantifiable. So compliance and legal officers at this organization would then conduct an inquiry to have actual knowledge that the claims were submitted and the amounts excess for the service. The only items that had been identified at this point were the claims as part of the chart review. Again, as Lori mentioned earlier, CMS may think differently, but we can't figure out how you could quantify claims that you haven't had a chance to look at yet. So you may be expanding your view of how those claims, or all the claims that could be in that universe within the timeline that are appropriate. Lori?
Sure. So what's next? Well, we do have an obligation to do further reviews. The first step is to look at the claims in that probe audit and determine and actually do some type of payback for just the claims that are failed after you've assessed like a provider schedule. But then at the same time, you should be assessing the probe to see if there is a percentage error rate that is greater than a certain percentage. So for example, if you're under a Office Inspector General's corporate integrity agreement, typically you would look to see if there's a net reimbursement error that's greater than 5%. And if so, you would need to look at potentially a statistically valid sample for the period audited. But I would also stop and ask myself how far back we have to go back. We talk about the 6-year look-back period, but we would also recommend probes into each year and probes within not just the physician's charts related to incident 2, but also the nurse practitioner. The key here is getting an accurate universe. Sometimes when we go in and do this, we're looking at, we get a data dump that has more information in it than is actually related to the issue that's at hand. And can we get to that issue? So do we know who the rendering provider is versus the billing provider? But we also need to stop and say, let's go, as we go back, when did this start happening? Did it happen from a particular training process that occurred, and then, or is it something because we had a system change and there was no way to monitor that? I'm not saying that's going to prevent us from going back those 6 years or 3 years or whatever, but we need to understand when this started to happen. And let's just say it goes back. We also need to assess each of those probes that we do into the prior years, determine if there's that 5% net reimbursement as well in those years. And that 5% net reimbursement for Incident 2 gets a little complicated because underneath Incident 2, the rules are is that a nurse practitioner is normally paid at 15% of the allowable, and when you bill it underneath the provider, you'd be at the MD rate, which is 100% of the allowable. So you need to calculate your net reimbursement, which is basically taking what was paid to what actually is the correct payment based upon how it should have been billed. as we're working through this sample analysis and data and universe and et cetera, and how far back we go, we also should have a corrective action plan from that initial probe that's helping us fix what's going on as we're trying to determine how much money we can quantify to go back to. So make sure you don't forget about that corrective action plan. And to me, some of those things would be working with the physician and having a communication with them about the problem and finding out, is it a training issue? Is it complete ignorance? Is it because he was incentivized to do that? Each of those would have different corrective action items related to that. But I would also consider that you may, after you've had that conversation with the physicians, have a process to hold that provider's claims and do review of them to make sure, hold those claims where they're still being billed on incident 2, to make sure that they're being accurately documented. Excuse me. And then as you design your audit, you want to look at whether or not that audit will encompass the right universe. Sorry about that. And that we are going to make ensure that we have the right population in there. One of the things that is always good to talk about is if we go back those 6 years and do some type of statistically valid sample, if it is actually cheaper to just do an extrapolation from our probe if we can do that with the data that we have. So think about that as you develop your corrective action plan. Sorry about that. Sheri, do you want to talk about recommendations and implications?
Certainly, Lori. We're recommending that organizations implement or really probably update their policy and procedure for reporting and refunding identified overpayments within 60 days. But we're also looking at about crafting this document so that the organization is thoughtful not to waive the right to argue the defense about the correct application and not to prescribe themselves into a box, so that they need to go through this process and identify a simple versus a complex case and what is required for those investigations and how that should go. So that we want to be sure you don't wait for 6 months for simple cases, and you also don't try to turn things in too fast. It's important to be able to complete the entire review. Additionally, revenue cycle groups should be updating their policies and procedures and be sure it's in sync with compliance. So perhaps in the past we've had separate policies, but now there are very stringent requirements here, and we need to be working together. Compliance and internal audit should be periodically auditing and monitor the timeliness, accuracy, and completeness of the reporting and refund, especially cases where the refund was generated through a compliance or audit review. If the compliance team has identified those, we should be receiving validation of the overpayments reported and refund. This is kind of a new key element, but if you're looking at good, complete documentation that stands up in 5 years when some other process goes on, you want to have all that information stored together so that it is very clear your practice was compliant, you were working through an investigation, and you have completed the things in a reasonable fashion. So take the KANE case as your anti-example. They did not have that documentation. That's what you want to have as you go through and have your policy and procedure and then your supporting documentation. Lori, do you have any other comments on the recommendations?
Yeah, I have a couple comments related to this. One is particularly we talk about compliance and internal audit being aware. One of the things that is important to remember is as our departments across the organization do monitoring of daily activity to make sure they're accurate and complete. So let's say data integrity audits. And we're doing that within a department, not in compliance, not internal audit. Maybe if coding's doing some auditing or HIM's doing the auditing. All of those areas where they may have opened a record, looked at and determined that some type of piece of the claim might be inaccurate, could potentially trigger that as being a issue that we need to investigate. So I think one of the concerns I have when we go into organizations is that we have a department that's doing audits, which are wonderful, or they're doing what they call audits and monitoring, but the results of those don't always filter up to somebody to make sure that that overpayment gets returned in a timely basis, or that they actually understand that there's an overpayment. You also need to make sure that you're thoughtful not to waive your right to argue in defense that the statute's correct application may be more protective than the policy the organization voluntaries adopts. So you want to make sure that you don't prohibit an early or interim report if the context and circumstance merit such a disclosure prior to a refund. So make sure that you have, you don't just say this is my policy and procedure, but also make sure you look at some of the rights that you have related to argued in defense. So Sheri, you want to talk a little bit about policies and procedures?
Absolutely. The report we need to have a notification to compliance about everything. We need to really be a collaborating team as we go forward with regard to refunds. And that, again, is all refunds, not simply the refunds that are appointed from the audit. The report to CMS should include the reason for the overpayment, for example, incorrect service date, duplicate payment, incorrect CPT, how the error was identified, the HIC number as appropriate, and the description of a corrective action plan to ensure the error does not recur. There are additional recommendations, as we've talked about, and we're going to read through them again because we're very cognizant of the importance of how the policy and procedure is crafted. It needs to allow for flexibility for changes during the investigation and for you to do a complete investigation. We want to create a policy that demonstrates the effectiveness of the compliance plan, that it's reported back through the compliance team. The compliance team is helping work through those areas. We want to define requirements for internal and external reporting and include internal procedures for approving and validating and confirming the amounts of refunds. And you want to ensure the policy is in line with compliance, accounting, auditors, finance, and legal counsel. That's a lot of people that we may not have had on our refund policy in the past. And we want to reference the organization commitment against retaliation for whistleblowers and reporters. As we saw with the KANE case, the significant damages were really in part due to a whistleblower action where he was identifying that he had provided the information and it was not being acted upon. We want to implement robust training and education, and sometimes we think that that's to the staff level. In my opinion, sometimes management needs to take that relook at things and make sure they understand what the requirement is. As Lori mentioned very early in the presentation, the Yates memo is looming large out there with your name on it and identifying that your name could be put in part of this if you're the one giving direction not to process these refunds. So we have to say. Go ahead, Lori. Sorry.
I was going to say one of the things I think important here is sometimes we go through our teams are going through the due diligence, getting the information pulled together and getting it set to refund or recoup, but there isn't that validation of that recoupment, or in particular if you have to file Medicare recoupment forms, and making sure that that is in a timely basis as well. Sorry, Sheri, you had more thoughts?
Sure. We want to make sure that we're assigning people to work through these issues in a timely manner, and we're not redirecting our staff that are supposed to be dealing with this and working through the compliance. And that can be one of those inadvertent things that happens where you end up with not timely submission of refunds. As we all know, the submission of refunds or even the process to create the refunds is a very timely process at the facilities, and it requires a lot of effort on the provider side. So we want to make sure people are keeping the right amount of people assigned to this project at that time. So Lori, you want to go over some guidelines for the investigation?
Sure. I think one of the things about the investigation that we talked about the WIF to the quantify, is really making sure that you're tracking within your investigation, and it's what the dates are when you receive the allegation to the time that you actually did the investigation to the time that you went to the overpayment process. I think we get buried down in the investigation process and we forget, okay, this is when the credible allegation was vetted, and now we need to figure out that overpayment. And so creating a systematic investigation plan and methodology will be really important to that, and having a centralized tool to track that. And as you go along, don't wait for the corrective action plans to the point where you're quantified like I've talked about before, but make sure that we address root causes. I was in a conversation yesterday with somebody about it's good now that we're actually getting to the root causes versus just investigating and fixing it. Let's go and make sure that it doesn't happen again. In asking that question 3 months down the road, are we okay as our controls that we've implemented, are they actually mitigating our risk for us? And then don't forget to come back and audit and monitor those controls, as I said, in the corrective action plan. I've been in situations where I've gotten a corrective action plan, and I go back to ask where we are in the monitoring of that, and the individual that was involved in the investigation said, oh, we didn't get time to run that report, blah, blah, blah. So let's make sure we do that now. So that's key for us to make sure that we follow back through with that. And make sure that those corrective action plans really get to that root cause. So, Sheri, do you want to give the audience our last polling question?
Absolutely. Our final polling question is really, where are you in relation to the 60-day rule in your organization? Is it fully implemented? Do you have it in place but it still needs work? Are you in the planning stage? Haven't started? Or you don't see a need for your organization? I think everybody can fit into one of these buckets. Let's give it a few seconds and see. All right, see what we've got. Great, we have some people fully implemented. The majority with yes, but still needs work. This is terrific. Just a couple people that don't see a need. So we're all over the place, but I think the yes, still needs work is really relevant in relation to the new final ruling and how we fine-tune that. I'll also make a comment to, as we're waiting for Medicaid's final rule, hopefully you'll be able to dust off your policy when Medicaid's final rule comes back out and make sure that anything new and exciting that comes out of there goes forward. So Lori, can you go over the key takeaways with our group?
Yeah, definitely. So we did go over the 60-day rule. We talked about some definitions, some things that we think are important for organizations to think about as they look at their compliance with the look-back period, what is considered to be that point where credible allegation occurs, and how you might want to go through and do your multifaceted investigation. And I think some of the things that, Sheri was talking about, making sure our procedures are up to date, making sure that we have education. I think one of the important things I've seen in some clients is where they've actually educated beyond the compliance officer and maybe the leads of patient financial services. What is the 60-day rule? When does it start clicking? All those type of things. So make sure that we can get compliance across the board. We have to have the team to support us to make sure we meet those areas. And remember that if something comes across as dark or fraud situation, you want to consider that self-disclosure protocols. And so it's time for you now to go look back at your compliance and your credit balance process to see what you have in place. We also wanted to do a little plug here at the end, and we'll take a couple questions after we get through some housekeeping. But we have a conference coming up on November 3rd through 4th in Las Vegas, and it's actually really good timing with the elections. We'll have a panel with the Newt Gingrich and Senator Joe Lieberman, and they're going to be having kind of a point-to-counterpoint discussion. And it's actually, in the last few years, it's been very interesting to hear different points of view. And as you can see, we have other great speakers, including Lisa from the advisory board and Ronnie from Google. So we have a really interesting conversations at our conference, and there's a link in the slides to be able to register for that. And also you'll be able to see the full agenda at that place as well. So there's quite a few topics that we'll be discussing at this. So that's our plug related to our conference. Here's our agenda, and I'd love to see you guys all there and come to the event. So I'm going to pass it back to Emily, and then we can take a few questions.
Great, thank you. We do have some time for a few questions today. If you have a question, you can enter that into the Q&A box and hit submit. Looks like our first question was, if we have an issue that is taking a long time to identify the dollars, what should we do?
I can take that one. If we have an issue that's taking a long time to identify, we want to make sure that we're looking and determining if there's an extraordinary circumstance. And I think one of the important parts here is potentially communicating with your payer or OIG or CMS about what the issue is. I have seen where we've worked with the OIG in the past for other clients and asked the OIG, this is what the issues are, why we're not getting to the number, and ask them clarification on our approach, and that actually helps them understand why we're struggling to get the number together. Okay.
Thank you.
Emily, another?
How does the 60-day rule apply to hospitals that are paid under periodic interim payments, PIP?
Sheri? I don't know if I have the answer to that one.
I believe it would be related to the final payment. So it's the claim payment, not the PIP payment that would be impacted. So it's the final claim payment and the identification of the overpayment at that point. So you would still handle the refund process as you normally would, but it's all related to the claim or the encounter's actual payment and then the identification of that payment.
Thank you, Sheri. The topic of physician supervision was mentioned in the clinic example. In the hospital setting, supervision based on the MFSP is an expectation and not linked to a CPT code for billing. However, in the clinic, you mentioned that it is part of the E&M. Is that correct?
Yes, that is correct. It's part of the E&M services, and if a nurse practitioner is the rendering provider and is being billed under the MD, there are specific rules on the documentation that has to go in place related to E&M coding.
Thank you. Can you let me know if this regulation is also applicable to private pay residents for monthly fees, overpayments, and entrance fee refunds?
Can you repeat that, Emily? I'm sorry.
Yep. Can you let me know if this regulation is also applicable to private pay residents for monthly fees, overpayments, and entrance fee refunds?
Well, this regulation is related to Medicare and Medicaid. So, and when we say private pay, the patients would not be covered underneath the Medicare and Medicaid policy regulations. So,
thank you.
but I would say you would want to follow some similar approaches, because sometimes with private pay, if you're not refunding that money on a timely basis, that's more, you end up with some media challenges as well. So.
Yeah, and additionally, the Medicare watchdogs are very interested in patients who have a private pay portion that's not being refunded to them if they're a Medicare beneficiary, if they overpaid the claim. So it's really best practice to provide all of your patients and or insurance companies a timely and accurate refund.
Thank you. Looks like we have time for one more question. When a practice is using a third-party billing company, how much of the liability lies on the billing company and how much lies on the practice?
Well, I'm going to say it depends on that, but I would say that you as the practice are responsible to make sure a claim is filed properly and accurately, and thus you're also responsible for any overpayment that's been created by a payer that's overpaid you. So you must have in place some type of way to monitor that third-party billing company for ensuring that they're returning those overpayments or sending in recoupment forms in a timely basis. When we've gone to some third-party billing companies, we haven't seen good controls related to this, and that's a huge risk for the practice, Sheri, do you have anything to add to that?
Yeah, I agree with you completely, Lori. The other portion I would have is be sure in your agreement with them that you're requiring them to spend the amount of time that's required to deal with the credit balances. Often their only reimbursement tool is the cash that they collect, and so their priority is very, very rarely on the compliance with payments and overpayments and refunds. And it is the provider is responsible for that. So you want to be sure that you they have a contractual obligation to meet that.
Great, thank you. That's all the questions that we have time for today. If you asked a question that we did not have time for, we'll be happy to follow up with you after the presentation. And thank you, Lori and Sheri, for a great presentation. As a reminder, if you attended today's presentation in a group and would like to receive CPE credit, you must complete the group attendance sheet in order to receive credit. You can download that from the slide deck and handouts widget at the bottom of your screen. If you participated as an individual and met all certification requirements, you may download your CPE certificate now at the bottom, from the icon at the bottom of your screen. Open the icon and click the printer in the lower right corner to download this now. I'll keep the webcast console open for a few moments to allow time, and a copy of your CPE certificate will be emailed within 2 weeks should you have any difficulties downloading it at this moment. And here is a link to an online survey where you can provide feedback for today's presentation. Please take a moment to complete this survey as your feedback is very important to us. Thank you for joining us today, and we hope you'll join us again next time.
Thank you.